For today's story, we are discussing a development coming out of Colorado, which is looking at the possibility of expanding the practice of law, at least in part, to non-attorneys. So this poses a whole lot of interesting questions. So let's go ahead and get started with this. The Colorado Supreme Court, which of course is the regulating body for the practice of law in Colorado, is considering whether to create a new legal license that would allow non-attorneys to practice some limited areas of family law. The controversial proposal would create a newly licensed legal paraprofessional position. Licensed experts allowed to represent clients in some divorce and child custody cases. I don't know about any of that. Family law is gotta be one of the most complex, emotionally driven, fact-driven areas of law. And to allow non-attorneys to this, I don't know, ma'am. The paraprofessionals could draft and file court documents, represent clients in mediation, accompany clients to court and answer judges' factual questions, but could not examine witnesses, advocate, or make arguments in court. So this is trying to create some sort of hybrid thing that would somewhat involve the role of a paralegal and sort of like, because paralegals very often prepare documents, basically, depending on the nature of the paralegal and what they're doing for you. Paralegals can do everything basically but sign their name on the bottom line. Some really good paralegals can basically prepare documents ready to go out the door, and then all the attorney has to do is sign them off. And so basically this would allow them in some situations to sign them off. So this is creating basically, or proposing to create, something that would be akin to the UK system and the difference between a barrister and a solicitor, which I don't particularly understand the difference incredibly well. My limited understanding is that solicitors are in the transactional side and barristers are the ones that practice in court. But yeah, so this is creating some sort of what you might call a solicitor role for these paraprofessionals, but in family court proceedings seems like a very weird place to do it, but okay. Proponents say the program will offer litigants a more affordable option than traditional representation by an attorney, and will decrease the number of people in family law court system who appear without representation. Currently, 73% of litigants in domestic relation matters represent themselves. So 75% of the time in family matters, people go without an attorney. And I mean, I guess they are the most sensitive aspects of law because they involve people's children. They involve the most sensitive matters available. But so we want them to get representation, but from these paraprofessionals, I'm not sure. The main driver here is access to justice, according to the chair of the Supreme Court's Advisory Committee on the Practice of Law. We're attempting to close the justice gap that we have in the United States, where a large segment of the population doesn't qualify for legal aid, but nevertheless cannot afford lawyers at regular rates. Opponents say the effort is misguided and inexperienced or unsupervised paraprofessionals could make mistakes or offer bad advice that may create more problems for litigants in the long run. I would think so, yeah. We would have to give people legal advice who then can't go and defend that legal advice in court. That sets people up for failure. Quite possibly, yes. The Colorado Supreme Court is soliciting public comment on the current proposal until mid-September. I have my doubts. I am dubious. Under the latest proposal, a person would have to meet particular education and experience requirements and pass a licensing exam to become a legal paraprofessional. Paraprofessionals would be required to complete annual ongoing education and could be disciplined and grieved like attorneys, and also subject to professional ethics rules. The licensed legal paraprofessionals would also be allowed to operate independently of attorneys and could maintain their own legal practices. They could represent parties in marital dissolutions only in cases where assets were below $200,000, and in custody matters only if the client's income is below as a yes-determined limit. See, this is where things make me a little bit sketchy, right? They're going to represent clients when it comes to custody issues over their children. Literally the most important thing, presumably, in these people's lives. The proposed rules are designed to ensure LLPs do not take on complex cases, but they involve children though, so they're all complex. LLPs will be required to decline representation and direct potential clients to attorneys in cases outside their scope. They're really intended to focus on simple domestic matters, cases that involve amicable divorces, where two parties just need help getting through a separation agreement and filing. And the same on the custody end, cases where the parents are in agreement as to a parenting plan and just need assistance getting through that, or someone who can guide them through a mediation process, which is required in family court. Attorney Elizabeth Bonanno, who is the president of the Interdisciplinary Committee of Metro Denver, a nonprofit organization, says the organization hasn't taken a formal position. Personally, she sees a clear need for the program with so many people unable to afford attorneys, but also sees potential challenges around the minimal real-world experience requirements and lack of supervision for the paraprofessionals. In addition to meeting education requirements, candidates would need to meet 1,500 hours experience in a law setting during 3 years prior to application, including 500 hours in a family law environment. They're assuming most people would be working in a law firm context, but attorney supervision is not required. So that's my concern. You can come out of this program and hang your own shingle, but you don't necessarily know what you don't know. It happens to every brand new attorney when you come out of law school. There's a lot of that. And as a non-attorney, you don't have the background knowledge of like the law in general, right? One of the things you get as an attorney is like at least a background knowledge in the law in general. Because a lot of these principles, of course, then can be refined in more specialized practice, but you have the generalized knowledge. And so here, you're basically trying to create a specialist without the underlying generalized knowledge. And that is really, really weird. And I don't know how that would work practically. I have many concerns. The concern is making sure the assistance is good and the results are well thought out. Because otherwise, the problem that happens is on the back end. Because when you try to undo things that happened incorrectly, that's when it becomes difficult for people, expensive. And sometimes damage has been done that can't be fixed. Only a handful of other states, including Washington, Utah, and Arizona, have such paraprofessional programs according to the report. Minnesota has a pilot program underway. The fledgling programs in those states are small. Utah has just 23 licensed paralegal practitioners 2 years into its program, with 6 more candidates scheduled to sit for the exam this month. Washington has about 66 legal technicians in its 6-year program. So apparently there are some very, very, very preliminary pilot programs. Paralegals in Colorado are not licensed by the state. That's typically true. Paralegals are not licensed because they work for lawyers. And so it's kind of up to the lawyers to determine what credentials they need or not. It's like, how would you even go about licensing a paralegal to some degree? Because like the lawyer's the one who has to sign off there and everything. So it's the lawyer's license. They're just kind of operating to help as an assistant. In Utah, the licensed program can take on any client regardless of client income administered. The state's program is similar to Colorado's proposal, though in Utah, paraprofessionals handle not only family law cases, but also debt collection and landlord-tenant disputes. Exciting and fun. Torres has said the program faced significant pushback from attorneys and legal associations when it's proposed. I would think so. You are trying to take something that is the practice of law and give it to non-attorneys. The practice of law has been something that's been developed over basically the last 1,000 years. And you're trying to give people who are not licensed lawyers the ability to practice law. Quote, there's a sense of elitism being an attorney in the way they view paralegals, and also a sense of market protection. I mean, that can be some of it too. Let's be fair. The attorneys might be concerned about their market, but then again, 75% of these people aren't buying their services anyway. So I think some of it might be protectionism, but a lot of it's just like, who are these people that are going to be practicing law? But overall, what it comes down to is the goal to serve the general public. Access to justice is more important than protecting the market. Yeah, but what is justice, and how do we ensure that they're actually getting that? Amber Elman, one of the first 4 people in Utah to become a licensed paralegal practitioner under that state's program, previously spent years working as a paralegal for an attorney. She remembers potential clients often calling to seek basic legal advice, but then balking at the hourly rate. It was $400 an hour, and you could almost hear people fainting on the phone. They couldn't imagine paying $400 an hour just to know where their rights are. $400 an hour is a pretty reasonable rate for an attorney, yes. Owlman charges $100 an hour, with a typical retainer of $1,000 for simple divorces or $2,000 for larger custody cases. She said attorneys in Utah were mad about the new program, and some were disrespectful to the newly licensed paraprofessionals. I would think because, you haven't gone through the same credentials, so we don't know what this is. Attitudes have still improved over time, and as more paraprofessionals have entered the field, she said, but attorneys can still force her off a case over even minor disagreements by moving the case outside her limited scope and forcing the clients to hire attorneys. If they don't agree with what you're doing, they'll say, I'm going to file a motion so that my client has to get an attorney because then they'll go to court. So yeah, they can only play within the bounds, and it's like, well, I'm going to force you outside the bounds. Proceedings must stay fairly amicable for her to stay on the case, she said, adding that opposing parties in her cases are usually represented by attorneys or are pro se. She's only handled one case in the last 2 years where both parties were represented by these limited professionals. Since 2019, there have been no complaints filed against the LPPs, but then again, there aren't very many of them. Most of Aulman's work is in uncontested divorce cases in which the parties come up with their own agreement, and she prepares the paperwork. Although Utah allows paraprofessionals to sit with clients in court, she does not. I just don't want to do that. My practice is more collaborative and more geared to resolution. If I need to go to court, there's plenty of attorneys who will do that. Thus, that brings us to the end of the discussion for the moment over Colorado looking to have some sort of program for non-attorneys to practice family law. Apparently, a couple other states have tried this to very, very limited numbers. So there seems to be less than 100 of these people floating around in all the states combined. And Colorado's looking at creating this for itself. I'm very dubious on this on a whole number of levels because I mean, you're talking about people's kids. And, dependent on, people might not know what rights they're giving up. And so they might think that they're okay with a particular agreement, but they're not getting independent legal advice about things, right? Because these people can't give legal advice. All they can do is kind of help them file the paperwork for things they've already thought to do, but maybe those ideas aren't good. One of the roles of an attorney, of course, is as counselor. And it's like, yeah, you shouldn't do this. So I don't know, man. I have a lot of doubts. I have doubts about their ability to do it. I have their doubts about what happens once they do. I have doubts about the whole thing. So I'm not sure, but I guess Colorado will experiment with it as it does. And at least for a moment, that brings us to the end of discussion of this case.